The discussion is going to be wrapped around the new law. The new ADA enhancement kind of narrows down, but more importantly broadens, I should think, the impact of the ADA, so it covers a lot more things. A lot more items are covered in major life activities. The new law talks to us about concentrating, talks to us about thinking and communicating. You will hear from our presenters how that will impact us. The new law overrides a lot of the past Supreme Court rulings. So court cases that we've become familiar with and have become our guide no longer are applicable. You will hear more about that from the others. So those of you that are faculty will need to know that the academic standards that we've aspired to at Creighton and other universities are not going to be changed. That's one of the things that the Senate put into the law. But again, you will hear more about that from the people that are presenting to us. I want you to take a moment now as Amy Bones comes to the table. Each of you know Amy. She probably needs no introduction, but I want to tell you that she's been the legal counsel for a number of years at Creighton and is a friend and a confidant that I go to often and will present really the keynote of this. So, and again, we're going to take a little break when this is all along, but welcome Amy now. Thank you.
Thank you. Can everybody hear me? Yeah? Okay. Great. We're going to talk about the ADA Amendment Act, which became effective on January 1st of 2009. And as Lena said, we really have a whole new law now. We may as well forget what we thought we knew about disabilities under the new law. And the first thing I'd like to talk about is why was this bill passed? And you can see up on the slide, my challenge is going to be, the slides are behind me, so hopefully I will keep up with my slides. But the reason it was passed, it was pretty eloquently put by Senator Harkins, who was one of the sponsors of the bill. The bill better defines who Congress intends to meet the definition of disabled. It clarifies that mitigating measures, such as medication, may not be taken into account when determining if someone has a disability. It provides guidance as to what is a major life activity, and most critically, it lowers the threshold for how limiting a condition must be and insists that the courts interpret the ADA broadly. For all of these reasons, the bill returns the focus of the ADA to where it was meant to be, on whether a person with a disability is being discriminated against. So we have a broad framework, and that's what we're going to talk about. Before we go on, I'm going to talk mostly about the ADA Amendment Act, but I want to make one comment. Some of you deal with the Rehabilitation Act because that's the act that says because Creighton gets federal money, we can't discriminate against somebody in educational programs. What the ADA Amendment Act did is it said, let's make the definition of disability under the ADA Amendment Act the same as it is in the Rehabilitation Act. So those two laws now have been coordinated, and the definition is the same under either act. Okay, prior law was being interpreted very narrowly. In fact, the ADA did a study and said in 2007, employers won 95.5% of the cases that were brought under the ADA. And when I say that, I am going to talk about a number of cases this morning, but I think the focus that we need to take is the ADA was never intended to be something that people had to litigate over. It was intended to help people that have disabilities be able to enjoy the privileges that a lot of us take for granted in terms of being able to hold a job, so on and so forth. So even though we're talking a lot about cases, I think we want to make sure that our focus is not on, this isn't a new, should not be a new piece of litigation. Okay, let me give you a couple of examples of cases under the old law where people were not able to prove that they were disabled. We have a case where this is the case of Ellison versus Software Systems. This was an employee who learned that she had breast cancer, immediately had a lumpectomy, and then received daily radiation treatment. She didn't miss work while she was undergoing treatment, but at her request, her employer allowed her to work a modified work schedule. So she arrives at work at 10:30 in the morning, following her radiation treatment, skips her lunch hour, skips her breaks, works till 6:30, and takes work home. Okay, sounds like a model employee. Series of events happen, and she is terminated along the way. She files a lawsuit claiming that she was terminated because of her disability. In that case, the court held that her breast cancer was not a disability within the meaning of the ADA because the impairment didn't substantially limit one or more of her major life activities. She had argued that she was substantially limited in the major life activity of working. The employer says, no, we didn't really have to give her any special accommodations, and she always was able to work. At the same time, the employee comes forward and says, yes, I was able to work, but while I was undergoing this treatment, I was nauseous, I was tired, I experienced all the complications and side effects from the radiation treatment, but because my employer let me work this modified schedule, I could still work. I think that the point of this case was the court said, no, you weren't disabled because you were not substantially limited in the major life activity of working. The court said she didn't create an issue on whether her cancer and treatment substantially limited her major life activity of working. Obviously, her ability to work was affected, but as reflected under the old ADA law, more was required to trigger coverage under the ADA. So what we have is we have a situation where an employee, really because they made some superhuman efforts to continue to work, really was denied the benefits of the ADA. That's the old law. So I just wanted to show you the kinds of things that were happening under that previous law. Let's talk just briefly. The core rights under the ADA and under the ADA Amendment Act, the right to not be discriminated against and the right of reasonable accommodation. And let's focus just for a minute on what's a qualified individual. A qualified individual with a disability can satisfy the skill, experience, education, and other job-related requirements and can perform the essential functions of the job with or without reasonable accommodations. How many of you, just by a show of hands, think that the definition of a disability changed dramatically under the ADA Amendment Act? Just how the law defines a disability. People that think it's changed dramatically under the new law? Okay, people that think the definition itself is about the same. Okay, the definition actually is the same. Let's look at it for a minute. Physical or mental impairment that substantially limits one or more major life activities of an individual, a record of having such an impairment or being regarded as having such an impairment. So the law itself didn't change, that piece of the law. What changed was how some of these terms are being defined in the new ADA Amendment Act. As we say here, the definition is fundamentally the same, and we really look at how things are going to be interpreted going forward. So let's look at the first one, substantially limits one or more major life activities. What the Supreme Court used to say is that meant you had to be prevented or severely restricted in your ability to do activities of central importance to most people's daily lives. So let me give you an example of a case that the Congress specifically said, we don't like this ruling in the ADA Amendment Act, and that was the case of Toyota versus Williams. In this case, the woman was an assembly line worker for Toyota, and she developed carpal tunnel syndrome. She was then not able to do the manual tasks associated with her job. She could, however, still do manual tasks that were not related to her job. So the Supreme Court said it was not sufficient to show that she couldn't do the job, her individual job. She would have had to show that she couldn't do other kinds of manual tasks. She would have had to show that she couldn't do housework, that she couldn't bathe herself, that she couldn't brush her teeth. Those were the kinds of things the Supreme Court said you had to show to be able to show that you were substantially limited in a major life activity. So the Congress has said, we don't want you to interpret substantially limited in a major life activity as narrowly as it was being interpreted before. And they charged the EEOC with coming up with a definition of what substantially limited is going to mean. They haven't done that as yet. We're still waiting for those regulations. But let's take a minute and look at the House report. There were two different bills two different versions of this bill that kind of got merged together. And in one of the versions of the bill, they would have used the term materially restricted instead of substantially limited. And in that House report, which somebody may look at or may not look at to say this is what really Congress intended, they say in the range of severity of the limitation, materially restricted is meant to be less than a severe or significant limitation and more than a moderate limitation, as opposed to a minor limitation. Now that's pretty clear. I mean, that's going to be one of our challenges, truly, as we look through this. There are so many areas that Congress didn't give us definitions. They kind of said on several occasions to the EEOC, come up with regulations. But I'm afraid what we're going to see, unfortunately, is we probably are going to see lawsuits again because people won't know how to interpret this new law. So, and one commentator says, let's not expect to see any regulations anytime soon. This person is saying if there's a broad piece of legislation out there, an agency may be hesitant to come up with regulations that might be a little more limiting. So at least from one commentator's perspective, the EEOC may wait for a while to really come up with a definition of what they're going to consider substantially limited. Okay, mitigating measures. Mitigating measures are things that would help someone with a disability to be able to do their job or to attend classes, so on and so forth. Some examples might be medication, eyeglasses, so on and so forth. Under the ADA and under Supreme Court decisions, mitigating measures could not be taken into account. The case here that's cited in the legislation is Sutton versus United Airlines. And in that case, we had two sisters, and they were not hired as commercial airline pilots because they didn't meet the uncorrected vision requirements of United Airlines. And they claimed they were substantially limited in the major life activity of working. And the court disagreed and said, no, you're not disabled because your glasses correct the problem. Okay, so under the old law, we could take into account what the effect of a mitigating measure was. The other case that they talk about a little bit was a case called Murphy versus UPS. And here was an individual who was fired from a driving job with UPS because he had high blood pressure. In that case, when he was terminated, he claimed he was disabled, and the court said no, because your blood pressure medication corrects your high blood pressure. So we'll have to think about the implications of what Murphy would look like under the ADA Amendment Act. But under the old law, as it says up on the slide, the Supreme Court said you don't ignore mitigating measures. You look at the situation with the mitigating measures. Now we have a different rule going forward. Now we do look at mitigating, we don't look at mitigating measures. So you look at what somebody's disability is like without the mitigating measures. And the next slide just gives you some mitigating measures. You can all read that yourself. Interestingly, you can still take into account whether somebody has eyeglasses or contact lenses. Otherwise, you look at the situation of the individual as if they had no mitigating measures. So let's look at Murphy for a minute. Here we've got an individual with high blood pressure who controlled that high blood pressure with medication. Under the analysis under the ADA Amendment Act, we would look at Mr. Murphy and say, yes, he has high blood pressure. Is that an impairment that substantially limits a major life activity? And the fact that he takes medication doesn't come into that equation. So that's a complete change in terms of how we would look at these kinds of cases. A couple examples. A person with epilepsy who takes medication to control seizures will most likely now be covered under the ADA Amendment Act, because we would look again, what would her limitations be without the medications? And a couple of other examples, diabetes and mental illness. Those things that are controlled through measures like medication, good diet, and regular sleep, again, may be found to be substantial limitations. And I think the point here is, and I'll just read from you from what one of the senators in the debate said, is a person with an impairment that substantially limits a major life activity should not be penalized when seeking protection under the ADA simply because he or she manages their own adaptive strategies or receives informal or undocumented accommodations that have the effect of lessening the impacts of their disability. Okay? They're really trying to level the playing field here for everybody, I think, is the point. Okay, moving on, you know, the definition of disability talks about substantial limitations in one or more major life activities. The first ADA did not define what a major life activity was and really left it up to the various agencies to come up with what they would consider to be a major life activity. The EEOC, for example, had a list that included things like caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working, okay? Again, think back on our case of Toyota versus Williams. The Supreme Court is defining that term major life activity very narrowly, again saying those activities that are of central importance to most people's daily lives. Under the ADA Amendment Act, and this is a side point here, there used to be some discussion about whether or not you had to be limited in more than one major life activity. The legislation now clearly says if you're limited in one major activity, that's enough. You don't have to be able to show limitations in a number of major life activities. And the Congress said, let's not interpret major life activities strictly. So again, it's a broadening of how we're going to look at things. So now we have in the legislation itself, rather than in regulations, a non-exhaustive illustrative list. And again, I won't read this. You can read it yourself. But you're going to see the list has expanded. And it's important to keep in mind that this isn't every major life activity. This is intended to be a non-exhaustive illustrative list. I'm just going to point out just a couple things here. Learning has always been has been in the list of major life activities. And now besides learning, you'll see we have thinking and concentrating listed separately. I'm going to leave this a little bit more probably for our panel discussion, but I just want to point out that there are some people that at least when this legislation was winding its way through Congress were concerned about thinking and concentrating being separate major life activities. So I think when we get to the discussion with our panelists, we'll talk about that a little bit. From my perspective, it would seem that thinking and concentrating were always components of learning, so to me it shouldn't be a big difference, but I'll be interested to hear what other people think on that point. The other big change in major life activities is now it includes the operation of major bodily functions, immune system, cell growth, digestive system, so on and so forth. These are kind of what are called non-volitional life activities, and there was always a little bit of a uncertainty about whether things that you had no control over could be considered major life activities. And the Congress now makes that very clear that yes, they can be. Immune system and normal cell growth, that indicates an intent to cover somebody who may have HIV or cancer, even if the person doesn't have any manifestation of those symptoms. So again, this is an area that people think really broadens the scope of the law. Episodic incidents are now clearly covered as well. So if somebody has, epilepsy, there we go, epilepsy or cancer in remission. If you have an impairment that is episodic, you can still be considered to be substantially limited under the ADA Amendment Act. Before, the courts would say, let's look at the overall situation. So you'd have to take into account the person has times when they're not having any symptoms versus times when they have symptoms. And a lot of times in an episodic situation, the person couldn't prove that they were disabled. Now the court is saying, I keep saying court and I mean Congress, when considering if a person who has an episodic condition or a condition in remission is substantially limited, we have to consider the limitations as they are when the condition is in an active state. So again, another broadening of the focus of the law. Now, if you thought all of this was hard to this point, which it is, it's complicated. Now I'm going to get to the part that I think is really hard. So I just want to forewarn you. This is the regarded as prong of the definition. You know, we have you have a substantial limitation in a major life activity, a record of such an impairment, or you're regarded as having such an impairment. The regarded as prong is the area we're going to talk about now briefly. And first of all, we're going to go back. Remember we talked about ADA versus the Rehabilitation Act, and there's a case that the Congress cites with favor in the ADA Amendment Act, and that was a case under the Rehabilitation Act where the Supreme Court noted that Congress acknowledged that society's accumulated myths and fears about disability and disease are as handicapping as are the actual limitations that flow from the actual impairment. So in other words, sometimes people with disabilities or with impairments that may not qualify as a disability, where the real battle comes for those people is in the myths and the stereotypes and people thinking they can't do something, okay? From the ADA perspective, this regarded as prong was just so truly was ignored. It was almost impossible to prove that you had an adverse action happen to you because someone regarded you as disabled, okay? That's not going to be the case under the new ADA Amendment Act. I'm just going to read this one slowly because, as I said, I think it's complicated. Under regarded as now, an individual can meet the requirements of being regarded as having such an impairment if they can establish that they've been subjected to an adverse action because of an actual or perceived physical or mental impairment, whether or not the impairment actually limits or is perceived to limit a major life activity. Okay, that's complicated. It's really complicated, I think. Another way to say it, maybe a little bit more simply, is to say an employee can avoid having to prove that they have a disability by showing that an employer, I'm going to talk here about employer, by showing an employer's actions were motivated by a perception that the employee has a physical or mental impairment, even if the employee does not. Okay? It's just really going to expand those areas. And I think from a university perspective, what we have to think about is, I was trying to figure out where somebody could come up with a regarded as claim. And I think the place it would happen most often is by comments made by other people in the workplace about the individual. I think if we really focus on conversations being about job performance, so on and so forth, and we kind of stay away from remarks that really don't have any place in the workplace, we're not going to find ourselves in a situation with a regarded as claim. But I want to go back to our first person, the woman with breast cancer, and I just want to read you a couple of the remarks that her supervisor made, which under the old law were not sufficient to prove a regarded as claim. But I would guess that under the new law, these kinds of comments might be enough for her to prove a regarded as claim. So remember, this is the woman that really was able to continue to work and did her radiation and so on and so forth. So her supervisor made 3 comments to her with respect to her treatment. First, when she informs her supervisor that she needs a modified work schedule in order to receive daily radiation treatment, her supervisor expressed his irritation by suggesting that she get a mastectomy instead because her breasts were not worth saving. Okay, I mean, these are, I used to think the only cases where these kinds of remarks were made were in the harassment and discrimination area. The second was she suffered from nausea after returning from a treatment. Her supervisor asked her where she'd been, and a coworker explained that she'd been in the restroom because she was sick. Her supervisor stated, the employee stated that she got sick every time she thought of eating or drinking. Her supervisor responded that it hadn't affected her weight. And I know we can sort of laugh, but I mean, you know, people just cannot make these kinds of comments. And thirdly, she arrives to work following a radiation treatment, and they have a power outage at work, and the employees were told to evacuate the building. When employees responded that they could not see because it was dark, the supervisor laughed and said, "Don't worry about it, follow Phyllis. Look over there, she's glowing." Okay? So those kinds of remarks really don't belong in the workplace. And from the standpoint of how would somebody make a regarded as claim, I think those are the kinds of remarks that really could get us in trouble. First of all, I don't think they're appropriate. And second, I mean, if you're talking about somebody's physical or mental issues, that's not a conversation to have in the workplace as far as I'm concerned. So that's enough of my lecture on regarded as. But let's just, to get back, what they're trying to do with this regarded as prong is they're trying to prevent employers from making decisions based on fears and stereotypes. One clarification is if somebody is perceived as if somebody is regarded as disabled, you don't have to provide them with reasonable accommodations, okay? If they are just regarded as, but they don't have what would qualify as a disability. Again, that's a little bit of a complicated point. But the main point to keep in mind here is you cannot discriminate against an employee on the basis of a perceived disability. It doesn't, this regarded as prong doesn't apply to an impairment that's transitory and minor. So if somebody has had a stroke or a heart attack, or recovering from a heart attack, something like that, with an expected duration of less than 6 months, then that person is not going to be able to bring a regarded as claim. So, like I said, I think that's a complicated piece of this law. Bottom line, more people will qualify as having disabilities. There's no doubt about it under this law. And I think a lot of time and effort has been spent in the past on trying to decide, does somebody have a disability? I think the focus will really shift away from that and will really go toward what accommodation have they requested, and is that accommodation reasonable? I'm not going to talk too much about reasonable accommodations, but that's really where we need to put our focus. I think Jeff will talk about that a little bit. And just very, very briefly, what is a reasonable accommodation? Any change in the work environment in the ways that things are customarily done that lets an applicant, employee, or I should have added student, enjoy equal employment or educational opportunity. And keep in mind that a big piece of this process needs to be that interactive conversation. If somebody comes to you and says, I need a reasonable accommodation, we don't necessarily, and they say, and this is what I want a new software system that costs $10,000. We don't have to give an employee or a student the reasonable accommodation they request. We have to ask them, what is it we need to help you be able to do? And we can have that discussion. So I think that's where we really need to be focusing our attention. I'm probably way over time. But very quickly, just one of the things that people worried about, not so much from an employment perspective, but from an academic perspective, is what was this going to mean for the accommodations that we give to our students? And it's important to point out here, nothing in the Act requires a post-secondary educational institution to make modifications that would fundamentally alter the nature of the services. Okay, and again, this will probably be something that Wade may cover a little bit more than I do, but just briefly, we're not expected to eliminate academic requirements that are essential to instruction, but we may be required to make modifications to let students with disabilities meet those academic requirements. And we can look at some of the modifications. That can include changes in the length of time permitted to complete a degree, substituting specific courses required for completing degree requirements, adapting the manner in which specific courses are conducted. We've talked about this a little bit. From a documentation perspective, we're going to shift from spending a lot of time collecting information about the evidence of a disability to the need for the requested accommodations. And then again, I'm kind of shifting back to the academic area. Is there a process in place to determine if an accommodation is reasonable or if it would be a fundamental alteration? And the cases suggest that before we would refuse an accommodation because we think it would lower an academic standard or fundamentally alter a program of study, we should undertake a review process. And basically that review process would include things like officials with relevant duties and experience would consider what the accommodation request is, meaningfully consider the impact on the program and the availability of alternatives, and reach a conclusion either that we can offer the accommodation or that it would result in lowering academic standards. Just very briefly, just a case under the old law was Wynn versus Tufts University, and this was a situation with a medical student who had really had struggled through, I think, his first year of medical school. He was at a point where he had failed his biochemistry class, and he wanted the accommodation. He did not want to take it as a multiple choice exam. So in the Tufts case, the university really documented a couple facts. One, how important biochemistry was to a medical school curriculum. Secondly, the fact that the multiple choice format provides the fairest way to test the student's mastery of the subject matter. and the fact that they had considered other alternatives and why they didn't think those alternatives were acceptable. So I think rather than just a flat, no, we can't do that, if there are some accommodations that are requested, we really have to go through an analysis that should be documented in terms of, yes, we considered it and we decided that there was no way we could offer that accommodation. So I think that's, just a last point, technical standards, which I know we have in a lot of the health sciences school, we really should look at those and make sure that those still are defensible under the ADA Amendment Act. Thank you.